I've got some thoughts about the new Texas laws that are affecting the zoning and the planning in the city of Garland and throughout the state. And any opinions in my statement are my own. They do not reflect any official opinions of the city of Garland or any of the individual commissioners or any of the city councilmen. I just want to let everybody know the changes taking place to the process of zoning and building in our city and all the state of Texas. As a result of recently passed legislation that became law on September 1st, you will see major changes in how this Plan Commission and the City Council handle zoning cases. The new law has greatly diminished the city's ability to guide or have any say in many aspects over what is built in Garland. Even worse is the legislation greatly lessens the impact of public input and citizen testimony before this commission and council. How did this come to be? A small number of cities abused their authority and overreached in writing and enforcing zoning ordinances and building codes. This legislation is a pushback too far in the other direction and hurts all the other cities and their citizens. I'm a firm believer in property rights of the applicants that come before us, the rights of those around an applicant's property, and the rights of the citizens of Garland. We in the commission take our job very seriously and try to balance everyone's needs, desires, and rights while making the best decisions we can for the city. Our ability to do so has been greatly diminished. Now to the specifics. The first bill is House Bill 2439, and it states, and I'm quoting, prohibits or limits directly or indirectly the use or installation of a building product or material in construction. This bill says cities no longer can control the exterior or interior materials used on a building as long as the material is allowed by the building code. Our masonry requirements that we had for houses and commercial buildings are gone. Our restrictions on where metal buildings could go in the city are gone. In planning developments, we can no longer ask applicants to change materials or to use a specific material. All those provisions in our Garland Development Code, as the bill put it, are void. There are exceptions for historical, conservation, and other special districts. And if you live in an HOA that has restrictions, those still apply. The legislation does not affect private restrictions. The next bill is House Bill 3167. House Bill 3167 is more complex and even further restricts Garland's ability to guide what is built. The bill affects the time we have to review plans and what we can consider in reviewing plans. By plans, I mean subdivision development plan, how a subdivision is laid out, site plan, concept plan, detail plans. Many of these types of plans are ones the Commission and City Council reviewed during the process of zoning. The first provision of the bill states that any plan must be acted on within 30 days of submittal or it is considered approved. Only the applicant can ask for an extension of up to 30 days. Neither the Plan Commission, City Council, or staff can ask for an extension or extend the 30 days. Many times we have voted to postpone a case so the applicant can meet with neighbors or address issues that come up during the hearing. We can no longer do that. To me, that limits the opportunity for citizen involvement. It also limits the opportunity for the applicant to work with citizens unless they've done so before submitting their plan. We have seen cases where interaction between citizens and developers has improved a project for both sides. That ability is gone. The second provision is that we must pass a plan if it is technically correct, and we may not do anything arbitrary. For example, we treat plats as technical documents. The property lines, the easements, and other items, if they're all correct, we are required by law to pass them. It has been this way for years, and why plats are now on our consent agenda. We used to use detailed plans, site plans, subdivision plans as planning documents to help shape developments and thus our community. We must now treat those plans as we do plats. If a plan meets chapter and verse of the Garland Development Code, we must pass it. If it does not meet it, we can deny it, but we have to cite the specific portion of the Garland Development Code that it does not meet. The developer then has as much time as he wants to fix any of the items cited and then bring it back. This applies to both the Commission and City Council. So a denial of a plan really isn't a denial if the applicant wants to make the changes and come back. What does this mean? It's impossible to write an ordinance that covers all aspects of development. For instance, if a development has multiple buildings and they want to put the taller one right next to the neighborhood, but that height is legal under the zoning and building code, we can no longer ask or negotiate with the developer to move the taller building to a different portion of the site. What is worse is that when citizens come up to speak about a plan, while they can talk about anything that they want because of the First Amendment rights, we commissioners and council persons can only consider specific ordinance references from the speaker. That limits the effectiveness of citizen input. This also affects the applicants in that we commissioners and council persons can no longer even make suggestions that could be considered in our decision. Recently, we had an apartment application come through where we made multiple suggestions to the layout and the design of the buildings. The applicant came back a couple months later, which is illegal now, has to be within 30 days, and they told us that they appreciated our input and were going to use many of our suggestions in future developments. Again, that ability is gone. Bottom line is we have to treat plans like plats, and we'll be putting many of them on our consent agenda. Now, a commissioner or citizen can still ask to have an item removed but for discussion, but again, we are still limited to what we can consider. Where does that leave us? The city still has control over the zoning of the land, the use of the land, and that includes planned developments. We will have the ability, we will have to look strictly at the use under all conceivable scenarios, good and bad, if it is, and determine if it is the highest and best use. No longer can we consider the layouts or pretty pictures applicants show us, as there is no way to hold them to those pictures and plans unless they volunteer to do so. We cannot ask them to include the material. They have to volunteer. Now, this is all a work in progress, as the city has only had a couple months to digest and try to work with the new law, which by all accounts is a poorly written law. We are now stuck with this for at least 2 years until the legislature meets again. Please bear with us as we do our best to comply with the law and continue to do what is best for the city of Garland. Now, if you have an opinion on these new laws now or as their implementation unfolds, please contact your local legislators and let them know. That's the only way it's going to get changed. Now, I personally want to thank Assistant City Attorney Brian England down at the end and the rest of the city legal staff for working so hard to bring the city within compliance and working so hard to try to explain to people like me and the rest of the commission about the law and what we must do. Now, I felt it was important for you, the citizens, to know and understand the changes that you'll be seeing over time. So I thank you all for listening.